case to come before the court is Richard Palmer versus Robert Bowers et al. Each party will have 15 minutes to present its arguments. The appellees, I assume, have been told ahead of time
Yes.
to split your time, and if you wish, you can let me know when you approach what that split will be. The appellant may reserve up to 5 minutes for rebuttal. If you'll just let me know that when you, before you begin, I can keep track of the time for you. The arguments are being visually and audibly recorded, so please keep your voices up and stay behind this podium. We've read your briefs and we are ready to proceed when you are.
Thank you. With the court permission, may I keep a bottle of water? I'm suffering from a cold. I'm getting parched halfway through the arguments. Thank you. May it please the court. My name is Timothy Fitzgerald. I'm here on behalf of the appellants. And if I could, I'd like to reserve 3 minutes of my time for rebuttal. Thank you. We are here this morning on a case in which the trial court granted summary judgment on a basis that is legally flawed. This case involves a fairly extensive, dare I say complicated, numerous facts that are in dispute, and we could probably spend the rest of the argument debating the factual disputes and ramifications of those facts. But that's not what we're here to talk about this morning. This is strictly a case which was decided on legally flawed grounds. And I would submit that given the extensive involvement the court had in this case in trying to unravel this corporate dispute, that the trial court judge, which included a receivership hearing and multiple pre-trials and status conferences, came to the conclusion that it would be best to try to resolve this on a very simple and what appeared to the trial court judge to be a straightforward, simple way of addressing and resolving the claims that are made in the complaint. And that is that a compliance with a contract between parties in a corporate setting, in this case it's a majority shareholder agreement that all but one party had signed, whether that compliance with that contract can trump and overcome an independent tort for breach of fiduciary duty. The complaint in this case involved 10 counts. We are only here today on 2 counts, count 9 and count 10. Count 9 is a claim against a defendant, Graham Hall, for breach of fiduciary duty that arose out of his involvement during the relevant timeframes in 2012 as a director of the corporate entity, Hall Contracting in this case, as well as becoming at a point in time during the summer of 2012 as the sole majority shareholder. Those 2 positions, which Graham Hall voluntarily accepted. He was voted as a director at a meeting in May of 2012 to become a director of the corporation. He accepted that. And as the briefs point out, during the course of the summer, he, through a series of what we call step transactions involving Robert McKenzie and Robert Bowers, became the majority shareholder, holding, I think, around 63% of the shares in Hall Contracting. There were fiduciary duties that attached to that transaction as well. And I would submit that there can really be little dispute in this case, that there is an abundance of evidence in this case of acts by Graham Hall, Robert Bowers, and as well Mr. McKenzie that amounted to Graham Hall's breach of fiduciary duty. And if I can direct the court to one piece of filing in the case that contains the majority of that evidence, it is the supplement to the plaintiff's opposition to Graham Hall's motion for summary judgment, which involves a multitude of emails between Graham Hall, Robert Bowers, and to some extent Robert McKenzie that lay out exactly how and why they were engaging in the transaction, that they were the secret of the transaction that they were engaging in order to try to amend the majority shareholder agreement to do away with certain provisions that they found unfavorable so that they could transition the control and ownership of Hall Contracting contracting to Robert Bowers. I would submit that it would be virtually impossible, I think, for anyone to read the emails that we put before the court and come to any other conclusion than that there was, in fact, a breach of fiduciary duty. And I submit that's why the trial court tried to avoid having to address those issues and came to the conclusion that he could dispose of the case based upon the simplified approach that merely complying with the majority shareholder agreement's terms somehow negated Graham Hall's fiduciary duties that he owed both as a director and as a majority shareholder.
On that issue, let me ask you, since what was filed in the complaint included some counts that were deck actions, or asked
Yes.
the trial court to declare, was the trial court permitted to, as you just said, avoid those issues?
Avoid them in what, I mean, he addressed them by concluding that the compliance with majority shareholder agreement resulted in those claims being dismissed. We're not here on those claims simply for the reason that the relief that we were seeking in connection with those deck actions can't be achieved at this point in time, given the subsequent events that have taken place.
What about count 9?
Count 9 is directly involved in this case, and that involves the claims against Graham Hall individually, again, as a director and a shareholder.
What was the trial court's declaration as to count 9?
That was not a deck action. That was an independent tort claim for breach of fiduciary duty.
I thought that was 10.
No, 10 was the civil conspiracy claim.
Gotcha, thank you.
Which involves
Okay.
Graham Hall, Robert Bowers, and Judith Bowers.
Thank you.
You're welcome. The law in Ohio is fairly well established that if there is an independent tort, the mere compliance with a contract does not trump that tort. In fact, just out of circumstance, I was reading the Green Book over the weekend, and in the December 17, 2018 edition, there is a case out of I believe it's the 7th District.
Is it in your brief?
No, it's not. And it's not really a case that is directly applicable here because it's not a breach of fiduciary duty claim.
We can't consider it.
Okay, very good. But the law that is stated in this case that I just read is cited in, or is consistent with all the cases that we've cited in our brief, including those cases that involve examples such as the duty of an insurance company for good faith. That regardless of whether or not the insurance company complied with the insurance contract, and or whether or not the insured has a viable clause of action against the insurance company for breach of that insurance contract, if the insurance company engaged in other conduct, independent of the insurance policy, that is a breach of the duty of good faith of an insurance company, there is a viable claim for breach of breach of the duty of good faith by the insurance company. That's what we're talking about here. A fiduciary duty by a director or a majority shareholder is a tort that is independent and can stand alone regardless of what contracts there may be. And there is one case that is cited in our brief that I think is on all fours and directly to point in this case. And that's the case out of the 2nd District, the Worthman versus, I believe it's DON net case, where the court expressly addressed the issues that we're talking about here. And majority shareholders in that case attempted to modify an agreement between the shareholders to make it more favorable to them in order to be able to discharge another employee, another shareholder. And the court said that regardless of the fact that the contract may have been complied with, there is still the independent tort of fiduciary duty. And the court expressly says at paragraph 57 and 58 that while the court isn't addressing whether or not the breach of fiduciary duty claim is in fact going to be successful, that it is an independent tort and can stand alone. And so the court reversed summary judgment. That is exactly what we submit to the court is the appropriate remedy and outcome that should take place in this case. So what were Graham Hall's fiduciary duties and how did he breach them? Again, our briefs lay out what the duty of good faith is in fiduciary duty is of a director. It is, requires loyalty, it requires good faith, it requires a director to refrain from self-dealing, and it requires the director to disclose material issues to the other directors in the corporation, and if necessary, to the shareholders. We would submit that Graham Hall, during the summer of 2012, violated each of those duties that he owed to the corporation, to the shareholders, and to the other directors. And I would point out that there was a directors meeting that took place in August of 2012, in the midst of when Graham Hall was engaging in this conspiracy with Robert Bowers and Richard McKenzie, Robert McKenzie, and Judith Bowers, where they were the directors, which included Graham Hall, Richard Palmer, and Mr. McKenzie, where they were discussing the future of Hall contracting. And at no point in time during that directors meeting did Graham Hall disclose to Richard Palmer that he was engaging in this secretive arrangement with Bowers and McKenzie to transition all of the shares first to Graham Hall and then ultimately to Judith Bowers, so that she could take over the company and turn the control of the company over to her husband, Robert Bowers. So at that meeting, at a minimum, it required that Graham Hall disclose all of those activities to the other directors. We submitted in this packet of materials, a supplement to our opposition to the summary judgment, the meeting minutes of that directors meeting. And there is not, at any point in time, any discussion about the transaction that Graham Hall was engaging in with Robert Bowers and McKenzie in order to allow Bowers to take over control of Hall contracting. So what did Graham Hall do that breached his fiduciary duties? He failed to disclose that involvement in the transaction with Bowers. He actively concealed the steps that were being taken. There's even an email that we've included in the packet. It's even cited in our brief, where there's discussion about the fact that Bowers is directing Graham Hall that make sure you segregate all these emails and destroy them so that Richard Palmer doesn't find out about what we're involved in. If, as the trial court found, this was such a legitimate transaction that was being done in compliance with the majority shareholder agreement, one has to ask, why was it so essential that the three of them do this in such a secretive manner?
You can do your rebuttal time now, it's up to you.
Okay, thank you. So again, he failed to make a disclosure. He actively concealed the steps that were being undertaken. During the course of the summer, when Bowers was no longer a shareholder of the company, he disclosed to Bowers financial information about Hall contracting. He gave him financial records. He gave him information about the company's cash position, its line of credit with the bank, all of which should never have been disclosed outside of the corporation. So I would submit there's an abundance of evidence here that Graham Hall breached his fiduciary duty. Let me just touch briefly on the conspiracy claim. That involves claims against Graham Hall and Judith Bowers. And the argument has been made that Judith Bowers should be granted summary judgment, or was properly granted summary judgment, because she did not commit any tort herself. And we've cited to the court the case of Williams versus Aetna Financial, which has been adopted in the 9th District, that in order for there to be a civil conspiracy, all that is necessary is that the conspirators or a conspirator either actively take part in a tortious conduct, they further it in cooperation or request by the other co-conspirators, they lend aid or encouragement to the wrongdoers, or they ratify and adopt the Wrongdoers Act, which is done for their benefit. All of those things Judith Bowers did in furtherance of the conspiracy. So the summary judgment on the conspiracy claim as to Judith Bowers and Graham Hall, because he was a co-conspirator as well, should be reversed. Let me just finish by my main argument by talking about Robert Bowers. He has filed for bankruptcy. He's been discharged. This court can't do anything to revive the claims against Robert Bowers. But any effort made to suggest that because he can't be held liable somehow exonerates Graham Hall or Judith Bowers should be dismissed, because as a tortfeasor, his actions are attributable to all members of the conspiracy, making all members of the conspiracy jointly and severally liable for those actions. So given the fact that he may not be a party that can be held liable at this point in time, does not serve to exonerate either Graham Hall or Judith Bowers. And so with that, we would ask that the court reverse the summary judgment of the trial court. Thank you.
Thank you.
Good morning. Between myself and the other appellee, I think we'll split the time. I'll take up to, but no more than 9 minutes, and reserve the remaining 6. Is that fine?
That's fine.
Yeah. Maybe I won't take all the 9 minutes. But may it please the court, Your Honors, my name is Fritz Berkmuller, and along with my co-counsel, Mathieu Acosta, we're here to represent appellee Graham Hall. I just have a few things I want to talk about this morning, but I'd like to start with this. There was no rush to judgment here. The 2 summary judgment rulings below were well-reasoned, built off of a full record, developed in multiple hearings. After vigorous debate by both sides. It's been almost 7 years, including this appeal. There have been 3 appeals, and the 2 rulings below were spread out, though they were separate, but spread out consistently over 2 years. It's time for this matter to end, and we'd ask that you affirm. If there were 2 things that I'd have you take away from my arguments today, it'd be this. First, of all that's been claimed in this case, everyone, the minority and the majority shareholders, received equal opportunities, equal access to the corporate opportunities. But secondly, of all the things that have been claimed in this case, the heart of it, going back to the very beginning, back in November of 2012, which dealt with the amendment and then the share transfer, that heart of it has now been dropped, expressly dropped from this case. But at the 11th hour, in the second reply brief in this appeal, after all these years, that's shocking, it's frustrating, but it's also a relief. I'll come back to that. First, I want to explain a little bit more about the equal opportunity and why that's an important point. The fiduciary duty laws that are discussed by Mr. Palmer's counsel, the cases and the code that deal with this, what they're meant to do is make sure that minority shareholders have an equal opportunity to share in the fruits of the corporation. But that's not what's been alleged here. His cases, Mr. Palmer's cases or his counsel's cases, they are consistent with that body of law. They talk about minority shareholders being diluted, having their interest diluted, losing the right to sell at a predetermined set rate, or being squeezed out of opportunities. But again, that's not what's being claimed here. What had always been claimed, was improper amendment and sale, a right of refusal and his right to buy. But each of these things were proper. None were prohibited by the contract, the majority shareholders agreement, or by the law. Coming back to the second point from my perspective, it's sensible that he would drop those claims, but it's damning to Mr. Palmer. Damning because there's no other wrongful acts separate from what was alleged with respect to the amendment and the share transfer. Everything, including the damages, which we have said are speculative, and did say, going back all the way to the summary judgment briefing, flows from that. And anything that's tied to that amendment, to the extent it needs to be discussed, needs to be viewed with disfavor and strictly construed. Because share transfer restrictions, as this court has held back in 2012 in the Puritas case, which we cited, are disfavored under the law and should be strictly construed. So what we need to do then is take those presumptions and use that to look at what we're left with here. The remainder of the case, having stripped out the heart. So Mr. Palmer's counsel suggested that there was self-dealing. There's no self-dealing here. What he's talking about is a change of control. That's specifically accepted under the code, 170160. It's not what is considered by cases to be self-dealing, some sort of shared transfer. It's not within the domain of the law. Secrets, there were no secrets. As Mr. Palmer admitted in his deposition, he had talked to Mr. McKenzie over the summer about the share transfer that might occur in the future. As we showed in our summary judgment briefing, there were email exchanges between Mr. Palmer, Mr. Hall, and Mr. Bowers talking about the potential for that sale. There's simply no secrets there. And with respect to bad faith, you know, Mr. Palmer's counsel refers to insurance law. Insurance law is completely inapt here. This is not an independent tort. What bad faith is under the fiduciary duty law is an exception to the business judgment rule. Business judgment rule protects the management of the company when things go wrong, when something bad happens to somebody, except in circumstances where there's a breach of the duty of loyalty, i.e. you were interested in the transaction, or where there's bad faith. But bad faith alone is not a breach of fiduciary duty. And here, there is no wrongful act, no harm separate from that majority shareholder amendment and share transfer, which has been described or claimed. So I don't know what bad faith would attach here, what it would attach to here, and I don't see how that can be the basis for breach of fiduciary duty or for reversing the court below. Bad faith can't stand alone, and the conspiracy claims can't stand alone. Without some underlying unlawful act, some breach of fiduciary duty, all of which now seems to have been dropped, there's no basis for saying that there was a conspiracy here. The intracorporate doctrine, which we did allude to, would be a defense if there were, but without that, there's just no conspiracy at all. And so if I could conclude where I started, there really was no rush to judgment here. There was a full record, a well-reasoned opinion after vigorous debate. We'd ask that the court affirm the rulings below, let this case end, and let us all move on. And if you don't have any questions, that's all I have. Thank you.
Morning, may it please the court. My name is Jamie Price, and I am here on behalf of defendants Applebee's, Robert Bowers, Judith Bowers, and Hall Contracting Services, Inc. Let me begin by stating that I agree with the arguments by Mr. Hall's counsel, so I will try and keep my remarks brief, as I don't want to go over what he just said, but I am in agreement. The only issue before this court with respect to my client Judith Bowers is whether she conspired with Mr. Hall in connection with his alleged breach of fiduciary duty, given that the amendment to the MSA has been held to be lawful and that part of the case is not being appealed. And I'd submit to you, and it is contained in our briefing, that there is simply no basis for a civil conspiracy claim against Ms. Bowers. Number one, and at the heart of the matter, there has to be an underlying unlawful act. There was no underlying unlawful act here. Now, Mr. Fitzgerald referenced the cases in his client's reply brief to somehow suggest that any alleged wrongdoing by Mr. Hall can somehow be imputed to Ms. Bowers in this case. And I submit that kind of misses the point, because in those cases, and in particular the Supreme Court case cited by Mr. Fitzgerald, the alleged co-conspirator was actually involved in the bad act. There wasn't an independent basis of liability, for example, fraud, because there may not have been a duty. But the alleged co-conspirator was actually involved in the bad act. The other elements of the conspiracy claim were met. There was a malicious combination with intent to injure and damages. And there is nothing in the record below that would suggest that any of those other elements with respect to Ms. Bowers have been met. As reflected in the reply brief filed by the appellants, the allegations with respect to Ms. Bowers are minimal and conclusory at best. They allege that Ms. Bowers somehow lended aid and assistance to Mr. Hall in this supposed breach of fiduciary duty. Submit there's nothing in the record below to find that. And then incredibly, they claim that Ms. Bowers is nevertheless equally culpable because she somehow ratified the actions by just purchasing the shares of the company. And I'll submit to you under Ohio law, that's not a basis for a civil conspiracy claim. And I think it would also lead to an absurd result. Here, what you have is Ms. Bowers, who purchased shares in a company, is somehow trying to argue that she should be held liable for the lawful acts of her predecessor shareholders in the company. And that would simply lead to a nonsensical result. So with that, unless you have any questions, I'll submit to you that the trial court properly granted summary judgment on the civil conspiracy claim with respect to Judith Bowers, and I would respectfully request that this court uphold that ruling.
Thank you. You have 29 seconds.
29 seconds? Okay, very quickly. Not once did you hear Mr. Burkmuller, Graham Hall's counsel, say anything about the breach of fiduciary duty regarding Graham Hall being a director. His arguments were all based on the shareholder law in Ohio. He breached the fiduciary duty as a director. They had equal access or opportunity. When was it that any of the other minority shareholders were offered the opportunity to buy the shares that Graham Hall and McKenzie were buying, or selling? Never, and that was before the majority shareholder agreement was.
Was there a requirement that they had to offer them to everybody?
Yes.
Before they could
Yes,
trade
it had to be
with
offered.
them?
It had to be offered first to the corporation, and the corporation refused to. This is under the majority shareholder agreement. Before it was amended, they had to be offered first to the corporation, and then any other shareholder had the opportunity to step in as well and buy those shares on the same terms. And it wasn't offered to Mr. Palmer. It wasn't offered to any of the other shareholders in the case. So obviously they were not given the opportunity to participate. Graham Hall sold his shares because he wanted to get out of a company.
You answered Judge Shaver's question.
Okay, thank you.
Thank you. All right, thank you for your presentations. Court will take the matter under advisement. We will issue a decision in due course. It will be mailed to all sides and then posted on our website and that of the Supreme Court.